Hello, my name is Jay Chauhan and I'm a lawyer in Richmond Hill, and this is a broadcast on the YouTube and also on the Facebook under Angel Mentorship Group, where we are also working together with the mentorship group. We have almost 120 members now, and I want to talk today about the examination for discovery. What is it and how does it work? So firstly, to put the examination for discovery into perspective, if you're a paralegal and dealing with the small claims court, the rules of Superior Court does not apply in the small claims court. They have a separate set of rules, so there is no examination for discovery in the small claims court. That's the point number one. The second thing is that the examination for discovery is a part of the procedure from the beginning to the end. So I'm just going to go through the overview of when does the examination for discovery happen. So in the Superior Court, you have a statement of claim, defense, affidavit of documents, which is the list of documents that you have on your side. The two lawyers exchange them, and if you are not represented by a lawyer, then you figure out the form, and then also have it sworn before a commissioner who is usually a lawyer, or it doesn't have to be a lawyer, and then serve it on the other side, and then you have the examination for discovery. So what is the examination for discovery? It's essentially a questioning process done before an examiner. These examiners are appointed by the government, and they have a license to lend their offices to the lawyers and the public who, under the rules, will set up an appointment and then give a notice to the other side that I am ready to ask questions to you on the particular situation of the documents that you have. So to do the examination, you have to have a form to get an appointment. So there are several examiners in the GTA, and you find the examiner that is under, you can look up the Google and find the examiner, and then you get them to give their form to you. You use the form. These forms are in the rules of practice. You serve it on the other side, and then you are ready to examine. But that readiness to examine is the procedural issue. What you really have to know is what questions are you going to ask. And I want to make a comment here that the way you will learn the procedures in the school, in bar admission, in the law school, in the rules of procedure, there are two major aspects of the law that you learn, actually. One of them is the substantive law, then there's the rules of practice, which is procedural law, to bring the claim or a defense of your client to the completion at trial. Now, examination for discovery is a method by which the parties are allowed to examine the other party under oath. So the notice, when you sent out to the other party, if you have a lawyer, he'll prepare the questions. If you do not have a lawyer, you should get to know how to frame the questions to ask. And a hint on how to prepare the questions is that you read the pleadings first of all and identify the cause of action, and then if it's a motion in examination, then you must read that affidavit carefully, and you are asking questions from your point of view to elicit the fact situation that will support your position. So, for example, if there is a breach of contract, you want to know, here's how you'll question. What did you have a written agreement? What did the agreement say? Is this a copy of the agreement that you had between the two parties? And you can mark it down as an exhibit, and then the transcript is prepared by the examiner. They charge you by the page, and he sends you the transcript. And this transcript can be used at trial. If you're in a motion situation, the transcript can be brought to the judge for the determination at the hearing. So this, in a nutshell, very quickly and briefly, what the examination for discovery is like. And the key element to what you have to learn, which is not taught in the schools, is what is called experience, is learning how to translate the questions that you have in the form of factual situations that support your position. So as I mentioned earlier, that if you have a contract, you want to know how and when the contract was created. There is a little bit of a leeway in the examinations to ask questions that will be almost amounting to cross-examination. So there is a certain amount of leeway under the rules and the case law that you can ask more questions to ensure that you have the fact situation presented. Because when you got the facts from the opposing side, they're putting it from their point of view, and this is the time for you to figure out the facts. Very often in Ontario, the examinations for discovery disclose to the lawyers, and if the lawyers are objective, and very often a large number of cases after the examinations get settled because each person, each lawyer on each side has a reasonable understanding of the case, the facts, and the law, which enables them to make a settlement. Hope that was of interest to you. Join our Angel Mentorship Group. This group is designed for lawyers, paralegals, and even the public interested in representing themselves. It's not legal advice. You should look for a lawyer if you want to go there, but hope that was of interest. And if you have a comment, write the comment below and ask your friends to join. This is J. John calling.